awful lot of subrogation work on construction defect, as well as such things as workers' compensation and property loss subrogation. But today's topic is on construction and construction defects. So we have to ask the first question, what is a construction defect? What are we dealing with here when we're talking about subrogation, or in that context? All right. Our experience here at Matthiesen, Wickert Lehrer, and I'm sure many of you have the same kinds of experience. We're dealing with a situation where maybe we as an insurance company represent a general contractor or a developer, okay, who have built multi-unit single-family housing development. Or maybe they've built a commercial building involving, hundreds of subcontractors. In situations like that, you have scenarios where subcontractors do the majority of the work, okay? And some of those subcontractors have subcontractors of their own. In terms of what is a construction defect, we're talking about situations where something in the process of the construction of the building, okay, was done incorrectly, all right, and now it needs to be repaired or put back into a situation or condition as if the contract was done in its as it was intended. In addition, that same construction defect, while it may have been defective in and of itself, it may have also caused damage to other property, whether other property located within the building itself as part of the building, or to personal goods, furniture, televisions, refrigerators, what have you, within the building or within the direct area of the defect which caused that damage. In terms of identifying what are construction defects, well, everybody knows that when you're constructing a building, certain standards are applicable for the overall construction of a building, the application of installing electrical parts of the building, installing plumbing, carpentry rules, things of that nature, okay? So the first thing you're looking at here is a violation of industry standards. Know what it is that the standard is, what is the practice in the industry that we're dealing with here, okay? It does vary on the location and use. For example, in California, when you're building or constructing a building, California, Southern California in particular, has to deal with situations of a potential earthquake, okay? In that scenario, what you're dealing with is you need a building which is robust, but at the same time incorporates certain building methods which allows the building to basically flex a little bit when an earthquake occurs, so that it doesn't just collapse in on itself by virtue of being too rigid. You're generally not going to find that kind of requirement and that kind of specialization, if you will, in a building built in Indiana or Wisconsin, for example. That's just your general framing kind of construction that you see in the majority of the country. But then again, that said, Southern California versus Wisconsin, Wisconsin, as we all know, is up north and has pretty brutal winters. You're going to want to take into account situations where maybe you're going to have more attention paid to the heat retention standards of a building, okay? Whether you use triple pane glass in the windows or insulation in the walls. In addition to variations on location and use, know where you're working, you also have some specific codes that are applicable to the trades that we're working with here. The Uniform Building Code, for example, addresses building codes generally with respect to how to build a house or how to build a commercial building. When you get into the specific trades themselves, the trades all have a code of their own. For example, the U.S. Electric Code is applicable to electrical installations. Moving on, you see here violations of building codes, federal, state, and local. In practice, more often than not, these codes are an adoption of the Uniform Building Code or the U.S. Electric Code or some other code like that. And the goal of these codes is mostly safety, okay? Obviously it's in the public interest, and therefore it's in the government's interest to ensure that buildings are being built to a specific standard so that the public, when using those buildings, is safe. It shouldn't be exposed to being electrocuted just by virtue of plugging in a curling iron, for example. All right? This is why when you're dealing with a situation of construction defect, it's required upon the developers and the subcontractors to pull permits to do particular installations, for example, installing the electrical system on a house or things of that nature. A third violation or construction defect would be a failure of a contractor or subcontractor to adhere to the building plans, the blueprints, in other words. The blueprints set the standard. The blueprints set the expectations of the customer for what it is that's supposed to appear in the building that is being constructed. If for any reason a subcontract deviates from that plan, whether it be just by virtue of negligence or they just didn't feel like installing a particular product because they felt it cost too much, those are violations that they're considered construction defects, and that is actionable. Speaking of design defects, this is applicable to developers and architects more than anybody else, because these are the folks who actually draw those blueprints, and they're the ones who decide what is going to appear inside the building itself. Okay, and if it's a situation where the building suffers from a design defect by virtue of the architect specifying a product which is no good for the use that is being used for, you can hold that architect accountable for the design defect of the building based upon what product they recommended be used on that building. Finally, a product failure. This is applicable to products that you find within the finished structure. For example, I've seen a lot of cases lately where a plumber has installed water filtration systems utilizing plastic canister filters that you find in a system underneath the kitchen sink. And for some reason, these plastic canister filters are cracking well before their due end of lifespan. And they're cracking at the threads of the canister, where the canister threads into the system itself. And the plastic is straight up not supposed to crack, okay? The result is when this canister cracks, it spreads water, it leaks a lot of water, so that's damage in and of itself. Moreover, when you have a water damage case, of course, the floor in the kitchen is ruined, the cabinetry is ruined, there may be mold problems, all that extra damage extraneous to the actual product itself. When you're dealing with a product failure, okay, the canister, you can hold accountable, for example, the manufacturer of the canister because they manufactured it and put a defective product into the market stream. You can also hold accountable the wholesaler who sold that product to the subcontractor, and you can hold the subcontractor accountable for that loss on the basis of strict liability, because if that subcontractor selected this product and that product leaked, they can be held accountable for also putting a defective product into the stream of commerce. Okay, the next slide we have here are issues common to every claim, and I think Doug's going to take over on this one.
I am, Chris. Thank you. What I'd like to do now is discuss some of the issues that are common to every construction defect claim that comes in the door. One of the first issues that I always look at, and I think needs to be looked at basically in any subrogation matter, but definitely in regards to construction defect matters, is whether there will be any insurance coverage available to indemnify any judgment that may be obtained against any defendant. Now, the most common type of insurance policy that may provide for coverage for a tortfeasor, such as a subcontractor in a construction defect case, is a commercial general liability policy, also known as a CGL policy. The purpose of a CGL policy is to indemnify an insured against any loss by reason of legal liability and to pay damages on account of bodily injury or property damage caused by an accident and arising from specific hazards. It's important to note that the coverage granted under a CGL policy depends almost entirely on the terms and conditions of the insurance agreement, as well as any exclusions and conditions of that particular policy. So if possible, it certainly is important for one to attempt to locate and review in detail any CGL policy that may exist insuring a subcontractor that we are attempting to pursue against. There are also a number of exclusions that are contained in those policies, and I'll talk about a couple of those in a moment, one being the your work exclusion. Before I do that though, I want to make a few additional points about your typical CGL policy. Generally, the standard CGL policy provides that will pay on behalf of the insured in construction defect litigation. We're usually dealing with property damage claims. In general, the CGL policy defines property damage as physical injury to or destruction of tangible property that occurs during the policy period, or loss of use of tangible property that has not been physically injured or destroyed, provided such loss of use is caused by an occurrence during the policy period. Now let's break that down just a little bit for a moment. First, under either definition, as I just discussed, the property damage must have resulted from an occurrence for coverage to exist. A typical CGL policy defines occurrence as, quote, an accident including continuous or repeated exposure to conditions which results in property damage. Now, since an accident or occurrence must take place for coverage to apply, your typical CGL policy will not contain, or will contain, an exclusion for property damage caused by intentional acts. We do litigation here at Matthiesen, Wickert Lehrer in all 50 states, and we are based in Wisconsin. So we certainly deal with Wisconsin as well as other states. But I wanted to point out too, and this presentation is not going to be state specific. We just don't have the time for that. But you know, typically courts and in Wisconsin, for example, when looking at whether property damage was caused by an occurrence, have looked at the Webster definition of occurrence or accident, which is generally defined as an unexpected, undesirable event or an unforeseen incident, which is characterized by a lack of intention. One court in Wisconsin, looking at that definition, also compared it to the definition of negligence, which has been defined as the failure to exercise the degree of care considered reasonable under the circumstances, resulting in an unintended injury to another party. In summary, one court here in Wisconsin is held as follows in addressing what all that means. It says, quote, it is significant that both the definitions of negligence and accident or occurrence center on the unintentional occurrence leading to undesirable results. As the courts have recognized in the past, CGL policies are designed to protect an insured against liability for negligent acts resulting in damage to third parties. And that is what a CGL policy is designed for, coverage for negligent acts. Let's talk a bit about another avenue of potential coverage that might be out there, and that would be the errors or an emissions policy, or an ENOR policy. Real brief, an ENOR policy is issued to professionals to indemnify them for their negligence in conducting their professional activities, their duties. One of the areas of construction defect litigation that we are involved in is claims against designers or architects. And those types of claims may provide coverage, and those potential defendants may have coverage under ENOR policies. The basic test under those policies is generally whether the design professional, whether they've been negligent, depends upon whether he or she has exercised ordinary care and competence as members of their profession. If so, there may be coverage under an ENOR policy, and that is also something to look in as well, both under your CGL policies as well as ENOR policies.
Yeah, Doug, if I could jump in for a second here. I just
Sure.
I had a case just like that. We're just wrapping up settlement on that case literally this week. Situation was we defended a developer who did a large reconstruction program on a strip mall here in the Milwaukee area. And the long story short is our developer client did the blueprints for the building and then also served as a general contractor and also did a lot of their own work in building out that building. The problem was that they picked the product, and it was included within the blueprints themselves, external masonry product for use on the exterior of this building. And the truth of the matter is that this product was not designed for exterior use like it was ultimately used in this building. The result is that 2 years down the road, after all the construction was done, this masonry product was deteriorating and basically rotting away, quite literally. Long story short, the owner of the building sued our client for breach of contract and negligence. Okay, they also put on notice the CGL carrier of our client as well as the ENO carrier. Okay, and the reason being is that because my client was both the architect as well as the general contractor, both of those carriers, I believe, and this is ultimately how it played out, carried a responsibility to pay on this claim. In fact, when it all boiled down to how this case is resolved, in truth, the CGL carrier was probably off the hook, in my opinion. Okay, I don't think they would have had to have paid anything because I think that the your work exclusion would have been applicable there. I think the E&O carrier was the insurance company that should have paid the entire claim because the reason for the failure in this case was a product selection issue. Our client chose a product which was just completely unsuited for the application that was ultimately used on this building. As it turns out, both insurance carriers paid towards satisfaction of the claim, but that said, you see why it is in a situation like that. There can be more than one party out there to go ahead and pursue a recovery against, whether it be a CGL carrier, an E&O carrier, or anybody else who may be. It's good to look around for those available deep pockets, if you will.
Okay, Chris, you mentioned the your work exclusion, and that kind of brings us to the next topic that I want to discuss, which is certainly an important topic, definitely in the construction defect litigation world. Your work exclusion is a exclusion that is contained in most CGL policies. Essentially what it does is it excludes coverage for damage to, quote, your work, which I'll give you a typical definition as found in a policy.
Real quick, Doug, we have a question here very quickly. Apparently somebody wanted to know what a CGL was. I apologize, and Doug will as well. CGL stands for Commercial General Liability Policy.
Correct.
Okay? And E&O stands for Errors and Omissions Carriers. Okay? Commercial General Liability is it's your standard liability policy that you'll see, whether it be for a construction company or a manufacturing company, things of that nature.
Thank you, Chris.
Yep.
In your work exclusion, again, is typically something that does not provide for coverage. Let me read you an example of a typical your work exclusion. What it states is that this insurance does not apply to property damage to work performed by or on behalf of the named insured arising out of the work or any portion thereof, or out of materials, parts, or equipment furnished in connection therewith. Again, this is an exclusion that is typically contained in your commercial general liability policy issued to a subcontractor, which basically says that there is no coverage for damage arising out of their work. Now, there's a case, and cases are, depending on which state you're in, certainly have different takes on how this exclusion applies. Let me give you an example about a case in Wisconsin. It's a Jacobs versus Russo case where that was exactly the issue as far as what damages were covered. In the Jacobs case, the defendant insured was a mason, and he allegedly did faulty masonry work to the driveway, sidewalk, and to the home of an insured. Now, all of the mason's work product had to be replaced as it was faulty, and there was no question about that. In addition, there was also damages caused to the home because of the faulty mason work. The issue before the court was what was covered and what was not covered. And in determining what damages were covered under the commercial liability, general liability policy, the court held that the landscaping, the driveway, the sidewalk, and the patio repairs, all done, were related to the insured's defective work and a direct result of accessing, repairing, and replacing the defective work. Thus, there was no insurance coverage available. Now, that doesn't mean there was no liability against the mason. Certainly there was, but the issue here is whether or not their insurance carrier has a duty to indemnify that contractor for the work they did. And in a case where it arises out of the direct result of the accessing, repairing, or replacing the contract or subcontractor's work product, there is usually no coverage. However, the repair of the interior of the residence caused by the faulty workmanship, was not a direct consequence of repair and replacement of the defective work itself, but rather was damage to other property. Therefore, there was coverage under that. So in summary, under this exclusion, the work exclusion will eliminate coverage for injury to or destruction of the product furnished or work completed by the insured, the subcontractor. However, if the defect in the product furnished or the work completed causes damage to other tangible property, there will be coverage for such damage to the other property. I want to briefly talk about another topic. Exclusion is the contractual liability exclusion. It's not listed on here, but it's certainly an important topic as well. Generally, the typical CGL policy contains an exclusion for property damage that arises from an assumption of liability in a contract or an agreement. For example, a typical policy exclusion states that insurance coverage does not apply to property damage for which the insured is obligated to pay damages by reason of the assumption of liability in a contract or agreement. Now, the reason that the CGL policy does not provide for contractual assumed liability is that CGL policies are designed to provide coverage for insured's tort liability, as we discussed, an accident, an occurrence. They're not designed to cover a breach of contract. Now, again, it doesn't mean there's no liability against that subcontractor for breach of contract. It just means if the claim is being asserted on a breach of contract claim, there likely will not be any coverage for it. Finally, I wanted to talk a bit about contractual indemnity obligations. And typically, the AIA contract, another document that when you investigate these claims, which Chris will talk about in a minute, you want to find out whether or not your insured, if it's the general contractor, may have entered into a contract, and typically an AIA contract with a subcontractor, and whether that's made part of the overall contract. If an AIA contract has been entered into, it's quite possible the typical language will include anti-indemnification language or anti-subrogation language, which will prevent potentially you as the subrogated carrier in pursuing a subrogation claim as against the subcontractor. Typically, those types of languages will state that the parties agree to indemnify each other from any claims being made, or even prevents parties and the insurance companies of the parties from subrogating against each other. So it's important to take a look at that type of language, and I know we've certainly had cases in the past where we would love to have pursued against certain subcontractors, only to find out that that subrogation potential was waived pursuant to those contracts. So take a look at that as well. It's an important topic. With that being said, Chris, why don't you then, unless you want to talk about that, but move on to the investigation aspect.
That's true. Before we get there, there was a question on who or which party would be insured by an errors and omission carrier. In our example, that would be the architect or the designer of the building itself, the person who drafts the blueprints, essentially. And Doug, just to carry on a theme here, addressing contractual indemnity obligations, well, you'll find that we like to tell war stories around here, and I have a good one in this case. What we mean by contractual indemnity obligations are those contracts that may occur between, for example, a general contractor and a subcontractor, or a developer and a general contractor. We settled a case earlier this year on a $4.5 million fire loss case involving the construction of a multi-unit 36-building condominium complex. And the general contractor was retained by our client, the developer and owner of the entire project, okay, to manufacture or build 6 of the 36 buildings. Towards the end of construction of one of those buildings, it caught fire, okay, and in the process it took down 3 total buildings out of the 6 that this general contractor was building. Its facts aren't important except to say that there was no doubt that the general contractor or its employees were negligent in causing this fire. No doubt about it, okay? That was the first place we looked to recover the damages, and unfortunately we were unable to do so. We could not hold the general contractor accountable in a first-party or a third-party subrogation action. And the reason we were not able to do so is because the contract language that existed between the developer, our client, and the general contractor, the defendant, stated that, among other things, there was indemnity language with respect to, thou shalt not sue me, you can't sue us. Moreover, there was anti-subrogation language wherein it was recognized by both parties that no other party, an insurance company, okay, could sue to recover the damages against the other one. Long story short, we knew who was fault here. It was a $3.5 million loss, and we could not take the action to sue the responsible party for the loss. Okay? All right, moving on. The investigation. Why investigate? We're dealing with a construction defect case like many cases. I find that the investigation in a construction defect setting is similar to an investigation in a product liability setting. The reason being is we're dealing with a situation where we're accusing someone or a company of having done something incorrectly, which requires a little digging to discover what that something is the best way of describing it. Okay, and when it comes to accusing a subcontractor or a contractor of basically doing work negligently, or even worse, committing fraud or something along those lines, okay, you have to be sure, and you have to ensure that your ducks are in a row, because basically what it is you're doing is that you're trying to build up your case as if you might have to go down the road and eventually do litigation, okay? So with that being said, why investigate? All right, number one, if it's your property or your insured's property, you are in the best position to identify and retain evidence. This is particularly important when you're dealing with a situation of a product having caused the damage to the building. Back to my filter system example again. If we believe that the plastic canister filter was the cause of a water loss because there was cracking at the ring where it screws into the system itself, we are going to want to retain that filter. And the truth of the matter is, if we do not retain that filter, we are giving the potential defendants, whether it be the manufacturer of that filter or the seller or the subcontractor, a defense, because they will be able to argue spoliation, which Doug will talk about a little later, okay, and say that they are prejudiced by virtue of the fact that they cannot examine that product themselves to determine if there is something really wrong with it, or if there's something else we failed to eliminate as a potential cause for the loss. Number two, catching witnesses when memories are fresh. This is not going to be so much as important in a construction setting as it is, say, in a fire loss property setting, okay? But if you have a situation where, you know, you have witnesses who saw a water loss as it began, okay? You know, you're going to want to catch witnesses early on, and you're going to lock them into positions in testimony, basically record them if you can, to find out what it is that they know and how their testimony may or may not help or hinder your case, okay? Identifying roadblocks. We're talking about indemnification, waiver language, things of that nature. You want to identify those roadblocks early by finding them in AIA contracts between you know, general contractors and subcontractors, your work exclusion in applicable CGL insurance policies. Identify those roadblocks early, because if they are valid, at least you know early on, and you're not going to waste a terrible amount of time and money and expense trying to investigate a case that you can't make a recovery on. All right, at least you know. Identify all possible third parties. Investigation should always include that, and probably most importantly, because in addition to your target defendant, whether it be a subcontractor or multiple subcontractors or your general contractor, obviously you're going to want to go ahead and look at their insurers, whether they be a CGL insurer or a ENOR carrier type of insurance company. Moreover, when you're dealing with a product that may have caused a loss, again, looking back at our filter canister situation, you're going to want to know who the manufacturer of that is and who sold that product to the subcontractor, because both of those two products, entities, in addition to the subcontractor, if the subcontractor installed the product and chose the product for that installation, are just as much as on the hook as is that subcontractor. So there's always more than one, well, I shouldn't say always, but more often than not, there's more than one potential third party out there from whom you can seek a recovery. Okay, here's the investigation. What are we trying to do? Okay, we want information on product or instrumentality causing the loss. Basically, you want to know what happened, and you want to know why it happened. All righty. You know, again, using our water filter situation, okay, that will not be hard to identify as causing the loss. Very simply, if you know, all the water will where the water is will point to where the damage was caused, okay, or where the loss originated. And it will not take much of an investigation to determine that the water started at that broken filter, and you can go from there to secure that filter and preserve it, okay? Also, doing the what is a means to uncover our subro killers, such as indemnity and waiver. Again, you want to get a hold of any contracts that are out there with your insured or with the general contractors versus the subcontractors, plus their insurance policies. It's a protection against disappearing witnesses and evidence by securing, again, our canister or other instrumentality of the loss, by getting witnesses under with a statement, okay? And you know, in the process of getting their statements, you get their addresses and their telephone numbers. 3 years down the road, when you find that you actually have to go ahead and file suit on this thing, you have their information. You have information that allow you to find those witnesses, even though they may have dropped off the face of the earth otherwise. Okay. Moreover, if you've taken a witness statement, for example, and it's 2 years down the road, that witness may not remember what it is that he or she said 2 years previous, but that statement that they provided early on in your investigation will act as a trigger to their memory and hopefully allow them to testify to your benefit. Okay, and again, it's an opportunity to cover third parties and sources of recovery. The how, you know, how is simple, and any of you who have been in the insurance business for any length of time, you know that the tools that you have available to you When you're dealing with witnesses, statements, and recordings. You know, if you can get a statement from a homeowner saying, hey, here's what I found, and here's how it happened, and here's what I saw, and here's what I did, okay, that's good. You want to keep that kind of statement, get that kind of statement, okay, again, for the reasons that we've already stated. Photographs, we've all heard the term photograph. A photograph says 1,000 words. No truer words were spoken. Particularly in a situation where you have a lot of damage caused by a construction defect. Showing the damage by way of a 8x10 glossy photograph to a jury does wonders in proving your case that this, what you say caused the loss, was in fact what did cause the loss. Okay. Preserving evidence, using our filter canister situation again, just collecting it is not enough. My recommendation would be that once you have that kind of instrumentality of the loss, okay, you are going to want to safeguard it, okay, and you want to record it by way of a chain of custody, okay. Sometimes it's better to actually get an expert involved who is trained and is versed in how to go ahead and preserve evidence so that it's not tampered with, so that it maintains it's maintained up until and through litigation, if no other reason, so that other parties, the potential third-party defendants, they have an opportunity to look at that piece of evidence 1-2 years down the road, and that's the biggest reason to hold on to it. Taking measurements is important when it needs to be done, okay? When you're dealing with a construction defect situation, taking measurements may not be all that important because taking measurements of a building are going to be pretty easy given the fact that you're most likely going to be able to secure the blueprints that came along with it, and they're very specific in the measurements, distances, and what have you. But then again, you're going to want a copy of those blueprints as it's applicable to that building anyway to ensure, if nothing else, that what was done according to those blueprints. Obtaining documents and reports. You know, if you have a situation where this is a construction defect case which caused a disaster like a fire, okay, you're going to want to obtain the documents and reports of other parties. You know, whether it be a police report or a fire marshal's report or an OSHA report for that matter, okay. You're going to want to get copies of those reports so that you can get an idea of what other people are thinking in terms of what the cause of the loss was, and hopefully, or maybe it'll help out your own claim. Engaging experts. Now, engaging experts is an open question when it comes to construction defect. Okay, we do a lot of property subrogation here as well, which and it frequently comes in the form of a after a fire. Okay, and you need experts in a fire loss case to investigate the cause and origin of the fire. Okay, the idea being is you need an expert who can point to where the fire began, and frequently you need another expert in the form of an engineer who says why the fire began or how it began. Okay, in a construction defect case, sometimes you need an expert. I shouldn't say that. Every time you need somebody who can testify to what it was that was done wrong. Okay. Whether you need to engage a third-party expert to say that is the question, okay? For example, we have a client who is a nationwide construction company, and they build, you know, 100-unit single-family housing developments in Florida, California, New York. Pick a state, they probably have something in there, okay? We deal with a lot of their claims doing exactly what we're talking about here. The subcontractor does something wrong. Our client pays out to the homeowner, the homeowners association, to repair that problem. Excuse me. All right, and then we're now going after the subcontractor to get reimbursed for what was essentially their fault in the first place. All right. Many times these losses don't amount to much more than a few $100s. Many more times they're in the millions of dollars. All right. For the small cases, you know, $500, $1,000, what have you. It's frequently, in fact, it is enough if the person who did the repair and who first saw the problem, first addressed it as it was being presented by the homeowner, the homeowners association, and then repaired that problem, they will serve as your experts to say essentially, here's what the subcontractor did wrong. Okay, and more often than not, it's the subcontractor or the contractor who comes in and repairs the damage in the first place. Okay, they'll say, all right, well. Using my canister filter situation again, a new subcontractor would come in and say, well, here's the cause of the loss. Your filter canister is cracked. Okay, that same subcontractor can go ahead and do the repairs, can testify as to why what was wrong and how it was wrong, and can also testify as to the scope of the repairs and why they were necessary. Now, for the bigger cases, $50,000 to millions of dollars, it may be beneficial to invest a little money to engage a formalized expert, okay, in the form of an engineer of some kind, okay, or somebody who is well-versed in the construction industry who can talk about deviations from the applicable building codes or applicable standards in the industry for installation of a product or installation of an electrical system, okay? Basically, when engaging experts, you get what you pay for, all right? There are the Lexuses and the BMWs of experts, and then there are the, well, what used to be called a Hugos. I don't believe Hugos exist anymore. But you get my point. The experts for $1 million case, it's frequently worth investing in a good expert who can give a very good opinion with respect to why it is a contractor or a subcontractor made a mistake and resulted in this $1 million loss. All right? And it only helps your case in the long run. But it's a case-by-case measuring ratio or a measuring approach to each case that you will have to engage in. Giving proper notice, especially when you're dealing with multiple potential parties, you want to give anybody who you think may be responsible to one degree or another for the loss notice of your loss, okay? They don't necessarily just have to jump on your and address your loss immediately. They can also ask to investigate the claim for themselves, look at the property, look at the instrumentality of the loss. They will ask for that stuff. And by giving proper notice, what you are doing is protecting yourself from an eventual potential spoliation claim down the road, which again we'll talk about, all right? And it gives them an opportunity to investigate the case themselves so that if you do have to sue them somewhere down the road, we're at least on equal footing to start, all right? Coming to conclusions, after you've done all your work, you want to make you want to come to some conclusion of what you want to do next. Are you in a position to go ahead and make a demand against a party or multiple parties? Are you in a position where you think you're not going to get any satisfaction just by making a demand because no one's going to offer you any money? You have to go ahead and engage subrogation counsel and have litigation initiated. That's the position you want to be in. You want to have done all that work so you can say to yourself, where do I go from here, and then take that action to actually go forward from there. Okay? All right, next we have, speaking of spoliation, Doug, I think you're going to handle this one, are you not?
I am, Chris. Thank you. Let's talk about spoliation for a moment. As is noted on our screen here, a good definition of what spoliation is found in Black's Law Dictionary as is the intentional destruction, mutilation, alteration, or concealment of evidence. Now, the reason that courts have and sometimes do assess sanctions against parties for acts of spoliation is that courts have determined that such acts undermine the truth-seeking function of the judicial system. They don't like that. So they certainly, it's something that's very important to take a look at early on in any subrogation case, and specifically in construction defect cases, to make sure that down the road the courts cannot argue that there was some spoliation that took place, which can in certain circumstances, kill your case. What spoliation essentially does is it comes down to whether a party has a duty to preserve certain evidence in pursuing a subrogation claim. Courts have not adopted a uniform common law standard as to when the duty to preserve attaches, unfortunately, and the courts have also not have consistently outlined the scope of that duty. Oftentimes, the scope of that duty is jurisdictional and even judge-specific. There certainly are some cases, some states that have more definitive answers as to what constitutes spoliation than others, but it is not something that nationwide exists. So it's certainly something you need to look at, and is very state-specific. In many ways, what the analysis of what constitutes reasonable notice is retrospective. What constitutes spoliation is retrospective. In essence, what the ultimate issue will be is, will a court someday, looking back, on the evidence that you kept and did not keep, with 20/20 hindsight, will they decide that you should have preserved more evidence than you did? That's the question. So anytime you are looking at an accident site or doing a construction defect case and deciding what evidence to keep, as Chris talked about during the investigation portion of the case, you always want to think to yourself, okay, down the road, is the court going to think we should have kept that piece of evidence? We should have preserved more evidence. And if so, err on caution. You want to make sure that you keep everything you think is important and could be important down the road to pursue your subrogation claim. You can turn to the next slide there. Some of this was already talked about, minimizing spoliation, and I just want to go over this in a little more detail if we could as far as evidence preservation and to attempt to avoid spoliation issues that arise down the road. We talked about a fire loss, and this could be any subrogation case, but typically on a home fire case caused by a subcontractor, an electrician who was negligent in doing electrical work, you want to, from day one, protect the scene. You want to make sure that all the evidence remains on the scene and do not do repairs until you and all other potential interested parties have an opportunity to inspect the scene. So you want to make sure you rope off the scene and make sure it's set up so that nobody can disturb the evidence that's there. Second thing you definitely want to do is put all parties on notice, all potential interested parties, all potential defendants on notice that an inspection will take place, and allow them to be there along with yourself and all experts, so that, again, an argument cannot be made that that you're trying to hide something and we're not open with the accident scene. Again, you want to schedule a joint inspection if possible, so that everybody can be there and has a right to do what needs to be done with their experts there. You want to establish a protocol or a chain of custody for evidence to make sure that no arguments can be made that the evidence was tampered with outside the presence of the parties, and to make sure that your experts have control over any evidence down the road, so arguments can't be made that it was taken out of the chain of custody. And as we discussed, you want to preserve the key evidence. Each case will be case specific as to what evidence is necessary to preserve, but again, you want to look at what down the road may a court think is necessary to preserve and err on the side of caution. And then finally, you want to move swiftly to prosecute claims. The longer you take to prosecute these claims, the more evidence goes away or memories diminish on witnesses, and so you want to move swiftly to make sure that you do prosecute these claims as quickly as possible. We don't have a slide for this, but I also want to talk briefly about sanctions for spoliation. There are cases where the courts have held that spoliation took place, that a party did not keep the sufficient amount of evidence to pursue their claim, and there's three different types and sanctions that courts have available to them. The first, you can do the next slide. The first is the adverse inference. And what that means is that if you do, in fact, pursue I'm sorry, I don't have a slide there. I apologize. Let me just talk about these, though. The adverse inference is that the courts may have a jury instruction to the jury as part of a case that you're proceeding with, where the jury is told to presume that because you did not bring the evidence to court, it's presumed that evidence would not help you. In fact, it would hurt you. It's a presumption against the despoiler, as they say. And all states have different jury instructions on that. But it's certainly something where it's not a good idea to go into court and have the judge tell the jury, hey, presume this guy, this party, because they didn't bring the evidence, that evidence would not help them. That is certainly one way, though, that the courts may sanction parties. The second and more severe sanction is a dismissal. And that has happened in cases here in Wisconsin as well as other states, where a court may strike introduction of evidence. And for example, the most recent case, or there's a case in Wisconsin where a subrogated party was attempting to proceed with a claim against a manufacturer of a product. However, they didn't keep the product and they threw it away. And when they came into court trying to prove up their case, they weren't able to, the defendants never had a chance to inspect the product. And so the court said, well, as a result of your failure to keep the product and allow the parties to inspect it, to render their opinions, we are going to strike your ability to introduce that into evidence. Without that important product, the evidence, they simply didn't have a case. And as a result, the case was dismissed on a motion to dismiss. And so certainly, in product cases, you want to make sure you keep whatever product you are claiming was the cause of the loss. The final potential sanction that exists in some states, not in Wisconsin, but in some states, is they do allow, some states allow a separate cause of action for damages under a theory of spoliation. And again, that's a separate lawsuit that you can file against a party for not keeping evidence, and if you can show, in fact, you were damaged by their failure to do so, some states do allow you to proceed with a separate cause of action. So that is the information on spoliation. I'm going to let Chris now continue with his next topic, which is on property damage and what is recoverable.
Thanks, Doug. We're going to pick it up here. As we frequently run into, we find we have much more in the way of material than we do have time. So if I start talking a little quicker than I already have been, I know it's already probably too late, but please forgive me. Okay, property damage. What is recoverable? What can you recover if you're insuring a general contractor or a subcontractor, or even if you're a general contractor yourself? Okay, depends on the jurisdiction, as do most things that we're dealing with. Okay, but generally speaking, what I've listed here, as you see on the slide in front of you, are the most general types of damages which may be available for recovery. Relocation, alternative living expenses, this has to do with the homeowner themselves. If the damage is severe enough that you actually had to go ahead and put them up in a hotel for a week or so, well, those are expenses which may be recoverable. Loss of use is also consideration. You know, the building, the house, whatever it might be, is no longer available for the occupant's use, and that may be recoverable to one degree or another. However, trying to prove exactly what that kind of loss should be is always the question. But then again, if you are, you know, long story short, it's a situation, it's a case-by-case basis in terms of what is defined as loss of use. Punitive damages don't come up very often. The long and the short of it is that a punitive damage is a punishment type of damage award. Frequently comes up in fraud or intentional misrepresentation kinds of cases. You're not going to see it very often, though, if at all. No, I shouldn't say it at all. You're not going to see it very often. There are a couple states out there that do allow for recovery of punitive damages for some in situations other than a fraud kind of situation where your subcontractor has deliberately, you know, committed fraud to get the job done, but clearly didn't do so to the satisfaction of the property owner or the general contractor. Emotional distress, also a very rare damage award. I believe California is allowing that now, however, and not many other states are doing it. But emotional distress is kind of hard to even request in the context of a breach of contract kind of case, because the contract spells out what everybody's expectations are, including what happens when there is a breach of contract. Cost of repair versus diminution in value. Okay, this does require an expert. What we're dealing with here is replacement cost versus actual market value. Alrighty, what's the building worth as it, you know, has the damage not occurred in the first place versus how much it costs to repair it? Well, what we mean by requiring experts, an expert will have to testify on the reasonable necessity of the repair costs, whatever those might be. In a situation of what is the building worth pre-loss, a property appraiser would probably be required to make that make that known, essentially. So frequently you get a situation where the defendant insurance company, whoever that might be, is arguing you can't get all it is you're requiring because that's replacement value, and all you're entitled to get is actual market value. Okay, getting the expert and having an answer for that kind of defense is why you hire an expert in the first place. Litigation costs, these are the fees required to file suit, deposition fees, service of process fees. Some states allow you to recover copy fees, things of that nature. Attorney's fees, not usually recoverable. Basically, I know, for example, in Wisconsin, the most I think that you can get from an attorney's fees is $300, right. And that is all, very nominal. The exception to that rule would be a situation where, again, you are suing on the theory of fraud and all its variations. Frequently, you have a situation there where fee-shifting statutes permit the party who is making the claim against a fraudulent party, and if they prevail, the attorney's fees of the party making the claim can be expected to be paid by the defendant. Expert fees, also not generally recoverable, except in very nominal values. I believe Wisconsin's up to $500 maximum But generally speaking, there is exceptions to the rule, again, on the fraud type of cases, but generally speaking, you cannot recover those in any great number. Moving on, because we are running out of time here. Limits on damages. I'm sure most people have seen these before. Contributory negligence, comparative fault. This measures the negligence of this, a property owner in our case. Was the property owner aware of the problem but didn't notify the builder or contractor to repair same? Long story short, if they discover, in our water loss case involving that filter canister, if the property owner had discovered that on Monday, but and water's gushing out from underneath the sink and doesn't call anybody about it for a week, that's on that property owner. That extra 5 days is on that property owner in terms of, why didn't he call anybody, the developer or anybody else, okay, to have that damage addressed immediately upon its discovery, rather than let it go on for 5 more days, in which case water is just rolling everywhere. In that scenario, yes, there's still damages to be paid, and there's still the initial negligence brought on by the the manufacturer of the filter canister, the installer, what have you. But where does that negligence and the damages end versus the property owner's own actions in failing to report the problem in a timely fashion? Excuse me. Also, with respect to a general contractor's actions in tort or contract, when is it reduced? When there's a subcontractor responsible for the loss? Frequently, you get a situation where we may have to go ahead and initiate a lawsuit against the general contractor because they're the ones who are ultimately responsible for the work being done in a building or buildings, okay? But it's a subcontractor who did the work. The general contractor basically can go ahead and do a third-party action and third-party in a subcontractor who is responsible for having done that particular job, which was responsible for this particular loss. In that scenario, the general contractor probably is not going to be let off the hook in its entirety, okay, in terms of the general contractor's own negligence, but he can share, the general contractor's own liability will be split to one degree or another, and it is a matter of percentages, with the subcontractor who is actually responsible for the loss. And the truth of the matter is, in that kind of scenario where you're representing the property owner or the insurance company who is suing the general contractor, you like that anyway, because it gives you more than one pocket to seek recovery of your own losses. And if it boils down to a situation where you can easily prove liability, somebody went ahead and installed this fraud or this broken filter canister, whether it be the general contractor or the subcontractor, I really don't care. Okay, let them point fingers at one another. At the end of the day, I still get all my damages back. So that's a good thing. Okay, strict liability, and again, I'm hustling here. Who is strictly liable? Depends on the jurisdiction, okay? And basically, in the context of a construction defect kind of setting, all right, we're talking about developers who are supplying mass-produced housing. This is the kind of developer who puts together a 100-unit single-family housing development, all based upon the same blueprint, if you will, okay? In fact, it treats a mass-produced house like a product similar to a car, microwave, or hair dryer. That in mind, damage, or when you're talking strict liability, we're talking about a concept of putting a product into the stream of commerce which was defective, okay? And the biggest reason for why strict liability is becoming popular nowadays is basically because it eliminates privity of contract, all righty? It means that the way the wave is developing, the way the thought process is developing is that it takes into account the fact that houses get bought and sold, and the person who buys a house at 6 years old from the original purchaser of the house, okay, doesn't have privity of contract with the developer or the general contractor who ultimately built that house. Strict liability allows that person, should a loss occur, say 7 years after the place was built, to go ahead and maintain a cause of action against that developer, against that general contractor, even though they had no relationship prior to whatever event caused the loss in the first place, okay? This is also applicable, I'm going to skip over that one line here about California. This also is applicable to suppliers and subcontractors as well.
And statute of limitations, Chris, let me take over here. This actually should have been the first slide. It's the first thing that I always do when I get a file in is I look at whether or not I'm going to have any concerns or problems with the statute of limitations or the statute of repose. And most of you, I'm sure, have dealt with statute of limitations and statute of repose issues. And as you know, it is very state-specific. One thing we do have on our website, which I want to point out, is we do have a chart that outlines all of the statute of limitations and the statute of repose throughout the United States, in all 50 states. And so I do encourage you, when you have a case that comes in and you need to know what the statute of limitations is or what have you, take a look at our website, and you will certainly have a nice chart there that can assist you in that. But with that being said, it is one of the first steps that you need to do as far as investigating whether or not your case has expired. Nothing worse than proceeding with the case and then realizing down the road, after expending time, effort, and energy and money, that there's no way you can file a lawsuit because one of the statutes has run. Now, the statute of limitations is generally a date specific as to when you can file a lawsuit, generally after the date a defect has been discovered, or after a date a defect should have been discovered with reasonable diligence. And so in Wisconsin, for example, there is for property damage claims, a 6-year statute of limitations for one to file a lawsuit after the discovery has been discovered or should have been discovered. The statute of repose, on the other hand, is a date specific in the future, and usually the date that is looked at is the date of substantial completion of the construction work. In Wisconsin, generally, it is 10 years from the date of substantial completion in which you have to file a lawsuit against that contractor. Again, every state is different. Make sure you take a look at the statutes that apply to your state with these particular issues. I do want to point out quickly the difference between a patent and latent defect, because it certainly is an important topic in some states. A patent defect is typically defined as a deficiency that is apparent by reasonable inspection. It's visible. Examples may be a sagging roof or a cracking sidewalks, interior drywall cracking, things of that nature that are clearly visible. By contrast, a latent defect is one that is not apparent by reasonable inspection. The reason I bring this up is, depending on your state, there may be different statute of limitations for latent defects versus patent defects, and make sure that when you are investigating any claim that you know the difference, so you can apply the appropriate statute of limitations. And then with that being said, I'll let Chris move on to some equitable contribution subrogation issues.
Okay, actually, on that next slide, we've actually covered most of what is already appearing on the equitable contribution subrogation slide. The only real point I want to bring out of this slide is that when you're looking at general contractor and subcontractor liability, remember, when you are trying to subrogate against a party, it is frequently more than just the one party, okay? It's always a better thing to know, to have, I guess is a better way of putting it, multiple pockets from which to seek a recovery. So when you're dealing with a construction defect case, the general contractor is generally just the starting point, always the best starting point, but you want the subcontractors to contribute to the loss or to your own recovery, okay? All right, moving on. Non-litigated claims. In many states, in particular California, there are some right to repair laws that must be adhered to or must be obeyed first before you can actually go ahead and initiate litigation against the responsible general contractor or subcontractor, what have you. Again, it's not all states. I think it's about 22 now at this point in time. Don't hold me to that. But long story short, right to repair laws acknowledge the fact that a contractor or a subcontractor does have the right to repair a problem with their work, okay? And the idea is to try to prevent protracted, long, expensive litigation and basically allow the parties, whether it be homeowners or homeowners associations, and those contractors who built a house or built something in the house, okay, to basically resolve the problem short of actually having to drag this thing through the litigation mud, so to speak, okay? Some states have required it, California being one, like I said. California has a very, is very proactive in this area. But basically it all stands, to one degree or another, they all ask for the same thing. Requires the homeowner to provide written notice of construction defect to the builder or the contractor. The idea is to, again, allow that builder or contractor to respond, okay, to take action if they are so inclined to do so, okay. Typically what happens is that contractor will want to have a look at the problem, of course, and then they are given the opportunity to do that, and then that contractor will basically either do one of a couple things. They'll either go ahead and repair the problem at no cost to the homeowner or homeowners association, or they'll negotiate and figure out a way to resolve it by some other means, or they'll just out and out refuse to repair it and say, it's not my fault, it's somebody else's fault. Okay? Regardless, if it's resolved, great. Everybody's done, no harm, no foul, nothing that further has to be accomplished. Okay? And also the homeowner has complied with the law. In no situation, however, does the homeowner give up their right to sue if the builder or contractor rejects the claim. Basically, what these laws stand for is these have to be accomplished first before suing can occur. Okay, so if the builder refuses to address the claim, well, the homeowner certainly can go ahead and sue that builder going forward. This applies to the homeowners association insurer as well, assuming that the insurer is paid for the loss to the homeowner's building. Subrogation in that respect applies to you also. Okay. Arbitration. Those of you who are representing, who are members of insurance companies who are also signatories to ARB forums, you know of what I speak. Okay. Generally speaking, if you're an insurance carrier and you belong to ARB forums, and your CGL carrier also belongs to ARB forums, both of you may want to go ahead and have the matter settled by way of arbitration. Okay, you all know it's binding, and as far as the outcome is concerned. You all know when you go ahead and are signatory to arbitration forums, there's a method for doing it, and there's a means of doing it, and it's very specific to arbitration forums. But you all agreed, your companies have agreed to be bound by whatever the arbitrator does. Okay. Long story short, arbitration serves the same function as these right to repair laws. They allow a claim to be addressed, okay, but without the expenses and long drawn-out process that is typically litigation. Okay. Okay, we are 5 minutes over. We have come to the conclusion of our presentation. We're out of time, so I don't believe we can take any questions at this point. A couple cleanup points, however. Our next webinar is scheduled for October 26th of 2010. It's scheduled at 10 o'clock, and it's going to be presented by Gary Wickert and called Subrogating Against God. That's always a good one, believe you me. And basically what we mean by subrogating against God is, for those of you who are in the subrogation business more generally, we have a situation, for example, where there's a flood, and someone says, and a loss is caused by the flood. Well, there are situations where, but for the actions of some other people, that flood would not have caused the damage it did because certain steps were not taken to, for example, make a good floodplain or something along those lines. Another,
we'll be sending out emails with that information about how to sign up for that seminar as well.
Sure. One final thing as well. If you have questions with respect for either Doug or myself, you can certainly go ahead and email those to us in the context of this webinar. Also, we do have a website, and the website itself is, I'll show you here. All right, our website here, it's mwl-law.com. It does provide a means for you to ask questions and email us with those questions as well. Okay, so we thank you for your time and appreciate your attention, and we hope we've been helpful here today.
Thank you very much.
All right.